It's 5:23 on April 30th, 2023. I'm in what was part of the land. I have other videos where I planted some plants. The problem is pretty much all of them ended up dying in here. This was the house, right? Okay. I found a series of baby strollers in the last year and a half. Not so ironically, the time frame I found them and the kind of baby strollers they are actually correspond with, and the child seats, actually correspond with what? Well, they actually correspond with my cosmology. Here are a bunch of shoes, baby shoes, right? I've moved the children into my house. Why? Because I understand that somebody is intending to impersonate me and is attempting to do something unseemly with children, while they also try to cash in on their April 30th deal in anticipation for their payoff tomorrow on that Christian conversion, which is not accepted. Most of the plants have already been killed. And as a matter of fact, some of them, as I've already got reported on here, were strategically targeted. My understanding is my growth has been retarded. Not anymore. I have here a treasury note I acquired last year, having to do issue date May 2nd. But the date dated is February 15th, 2022. This is a 19-year, 10-month bond. Right here, I have a cover sheet. Annual Report of Blocked Property, United States Department of Treasury, Office of Foreign Asset Control. In connection with a report that I filed with the Office of Foreign Asset Control concerning an account I had opened in Honduras when I was a teacher in a bank that was later seized as part of a treasury bust of a Honduran businessman that itself was later identified as liquidated. You can see here, there is the cover sheet, and right there, my name, right, information about how to contact me. Date prepared, 5:12 p.m. CST on September 22nd, 2020. It just so happens to be exactly 1 year before the time frame in which I was supposed to be evicted. I contend they knew that. And that's exactly what they were trying to do in this completely illegal scheme. This right here, from case number 3:21-CV-2126, Samuel Ellsbury Trust 2019, Edna Elizabeth Ellsbury Trustee versus Charity Colleen Crouse and an NDTX. Motion for expedited foreclosure. I'm going to read this now. Per Texas Rules of Civil Procedure, Rule 736, expedited foreclosure proceeding, Charity Colleen Crouse hereby files an application for court order to foreclose on lien on 5916 Birchbrook Drive, number 231, Dallas, Texas, 75206, and other properties due to Crouse for forfeiture as attested to via motion on failure to establish title as presented on October 21st, 2021, in case number 3:21-CV-2126-K. As of February 18, 2022, it has been more than 120 days since filing of motion on failure to establish title. Today is 7 days since. In the event of an eviction proceeding, the foreclosed would have 5 days to appeal. Information has come to light that on February 23, 2022, another person in a similar matter had been involved in a proceeding providing her claim as recovery on forfeiture. In addition, evidence was provided to Crouse of a bond issued on February 21, 2022, for a criminal trespass charge regarding a court date scheduled for April 18, 2022, that attests to Crouse's original claim of September 3, 2021, and as presented in affidavit provided in court that was dated for August 30, 2021, that an unlawful proceeding, including derivative action, had been engaged to, quote, elicit a bond on the good faith and credit, end quote, of Crouse in order to engage a scheme to defraud in another crime in furtherance of said scheme. Crouse had ready a motion as of February 23, 2022 for presentation in said matters, but due to outage of available electronic filing processes, as well as public transportation disruptions in the course of an alleged, quote, weather-related event, end quote, was unable to access a means by which to communicate with the court. Despite the notice of November 16, 2021 by alleged, quote, senior judge Sidney Fitzwater, end quote, or most recent effort by Crouse to contact the court on February 18, 2022, Crouse contends her request for a motion to compel discovery was not appropriately considered before the court, and that in light of evidence that has been acquired since November 16, 2021, including as a follow-up to evidence originally submitted for consideration on September 7, 2021 and later, that Crouse's original charges regarding federal violations, as well as violations to the Texas Constitution, still stand and have been vindicated beyond a shadow of a doubt. Crouse believes the evidence demonstrates her allegations that a fraudulent mortgage was acquired in January 2021 and was connected to acts of fraud associated with Crouse's affirmation in July of 2019 of her homestead claim via a, quote, transfer of deed, end quote, recorded exactly 6 months after the date by which Crouse's homestead claim would have begun establishment and is the second instance of an execution of an act of, quote, securities fraud, end quote, involving a security instrument on the property. Additional evidence regarding acts of, quote, mail fraud, end quote, substantiate those and other charges and indicate that there is currently a lien on the property attempting to compel Crouse to perform. That the, quote, Samuel Ellsbury Trust 2019, end quote, has refused to relinquish unlawful possession of Crouse's birth certificate and driver's license, while evidence of representation of Crouse is still legally residing at the address, i.e., jury summons and voter registration renewal. Without Crouse being able to return to access her own property, having her keys returned, or being given a return on her stolen birth certificate and driver's license demonstrates another person is misrepresenting themselves as Crouse and or as legally entitled to access or use Crouse's identity and property. Additionally, evidence Crouse listed on Evidence List 2 is available for consideration of additional charges of tampering with evidence insofar as new mailings from the same entities as listed in evidence, previously under the names of undisclosed and unconfirmed women, have been sent to the address under the name of, quote, Samuel Ellsbury III, end quote, which was the name represented to Crouse as being the person whom owned the property prior to Crouse's arrival and the person whom was the trustee of the trust responsible for securing the property. The only documentation provided on the title or deed holder of the property presented to Crouse was provided through the County of Dallas Public Records and, as acknowledged in the motion on failure to establish title, provides evidence of intent to engage Crouse in a scheme to defraud at the onset of Crouse's relationship with Ellsbury in May of 2019. Additionally, until this time, no judgment order has been provided by the alleged trustee, Edna Elizabeth Ellsbury, end quote, or her attorney, Kim Sims. No documentation of their legal right to access, much less possess any property, has been provided. No bond for possession has been provided. All actions in the proceeding are in direct violation of Rules 717, 718, 719, 720, 722, 724, 728, 730, and 732. Additionally, still, Crouse contends that as of February 28, 2022, the, quote, Samuel Ellsbury Trust 2019, end quote, intends to illegally lien on Crouse as abuse of Rule 731 in manners that have occurred previously since the appeal was first submitted in the federal court. Crouse contends that Rule 732 should be considered since 10 days after Crouse was illegally removed from her property and also filed an appeal with the federal court on September 21, 2021. As such, damages in regard to the property cannot be released from consideration, including as they continue to accrue, as addressed in the October 21, 2021 motion on failure to establish title per Rule 730, including in regards to interest and cost of the court. The matter is requested to be considered in light of the implications of Rule 734 and that failure to forestall further crime in this scheme to defraud has incurred unlawful levies upon other properties comparably engaged in the scheme, including the potential that new properties have been implicated in the time since the court refused to respond. Due to the nature of the charges, federal jurisdiction is established concerning securities fraud in violation of federal law and with interstate implications, as well as consideration of the attendant state constitutional violations. See earlier notice to the court in the event that instruction to the local court for moving forward on court order for foreclosure is needed as the process for moving forward on the federal charges is pursued. The court is requested to consider the request for the court order for foreclosure in the context of the profundity of the charges and in consideration of Crouse's earlier efforts to appeal order by magistrate judge, as well as ordered to remand to County Justice Court. Now, for the record, this right here, what did I say? This is completely unacceptable. It has been more than a year and a half. It is obvious that the refusal of the court to do its job as the court is responsible for significant crimes. I understand we are in another situation comparable to what happened last May 23rd. It is completely unacceptable and inexcusable for the court or anybody else to interfere and allow for this crime to continue perpetuation.